All right. Our next item on the agenda is the OPMA training. Nancy, where is Nancy? There you are. All right. Welcome. This is Nancy. Is it Crier? Creer. Thank you. Nancy
Creer
is an assistant attorney general. Wow. I'm going to move.
Yeah.
And she is going to tell us a little bit
It's
about.
not going to be an interrogation.
That's all right. Yeah, I didn't know that was going to be this difficult. She's going to talk to us about the Open Public Meetings Act and offer training for the governors and our staff. Go ahead, Nancy.
Well, thank you. I appreciate the kind invitation to be here today. I do open government training around the state. I'm the Assistant Attorney General for Open Government, the ombuds, if you will. I train about 3,000 to 5,000 people a year. Plus, we have online training that many thousand people have accessed. So sometimes when people come up to me and say they've seen me in training, I'm not clear if they've done it via YouTube or in person because I've seen so many people. Plus, I'm kind of a star on YouTube. So having said that, I've got a presentation for you. We'll kind of walk through the Open Public Meetings Act. And when I use the word you, it's nothing personal. It's just the way I talk, what you would do. I am aware you've got some litigation going, and I'm not specific to that. It's the way I talk, okay? So we'll just begin with that. Oh, and by the way, I used to be a liaison to the Bar Board of Governors for Washington Women Lawyers and the Government Lawyers Bar Association, so this is my first time back since doing that, so thank you. So let's just begin. Our state Open Public Meetings Act was passed in 1971. It actually was a cleanup. There was a potpourri, if you will, of meetings laws scattered throughout the code. And in 1971, the legislature sort of grouped them and reorganized them and codified them in RCW 42.30. So it came from the legislature, this particular law. It requires meetings of the boards, county commissions, councils, committees that are subject to this law to be open to the public, gavel to gavel, unless a law permits closure, and we'll talk about a few of those in a moment. So the stated purpose is right there in the code. If it looks familiar to you, it's because it's also a stated purpose in the Public Records Act, which is our other open government statute in this state. They're codified in two different places. So the purpose is the people do not yield their sovereignty to the agencies which serve them. The people in delegating authority do not give public servants the right to decide what is good for the people to know and what is not good for them to know. And the people insist on remaining informed so they may retain control over the instruments they have created. And when I get questions from time to time about, well, who pays attention to this old purpose codification, the courts do. So when they have a case and they're debating about, whether the OPMA should apply or applied in this particular activity, the arc will bend towards openness. So this is the presumption from which, the grounding, if you will, from which we operate with this particular law. And like I said, like the Public Records Act as well. So in addition, the statute provides that the public commissions, boards, councils, and we'll talk about those in a moment, are agencies of the state that exist to conduct the people's business. So their actions are to be taken openly and their deliberations conducted openly. And again, that's right there in the code. Then in the latter part of the code, it provides that the act is to be liberally construed. So again, right there in the statutes, that arc bends towards openness, towards disclosure. The state Supreme Court has described that the purpose of this act is to allow the public to view the decision-making process, not just the final decision. So the public gets to see the sausage being made. That's the point. And sometimes when I work with boards and councils who may have recently come off of, say, a nonprofit board or a homeowners association board or something like that, they will say, well, we only took action and we did that in public, but they're referring to vote. This law operates differently. It's all those things leading up to the vote, as well as the vote, that have to be done in public. In another case, the state Supreme Court, which recently this case was quoted again by the Court of Appeals, the state Supreme Court said that this is some of the strongest language in the code. And we're not talking just about open public meetings, we're talking about the entire code, this purpose statement that the act is to be liberally construed and the public gets to observe the process. So you've heard this before, I've already mentioned it. These are often called transparency laws or sunshine laws. Every March there's Sunshine Week. You see a lot of editorials run about public agencies and openness in government during March, and it's in part because of this Sunshine Week. And Justice Louis Brandeis once, famously said, you've probably heard this, that sunlight is the best disinfectant. So transparency builds public confidence in government because the people can see what's happening in their agencies.
Those of you on the phone, please mute your phone when you're not speaking.
And I didn't have this slide up, but sometimes I have a slide from the Dalai Lama. I just didn't know if you wanted to deal with the Dalai Lama at this hour of the morning. But the Dalai Lama also said that once you have trust, everything flows from that, and transparency builds trust. So again, this sort of thought process of the openness is important to many areas, but certainly to this area. So unlike some of our transparency laws, the Public Records Act being an example, which applies to every government agency, school districts, special purpose districts, large agencies, small agencies, what have you, the OPMA only applies to the multi-member state agency and local agencies. So you usually see the word board, commission, council, committee, that multi-member entity. And then they are listed right there in the statute. So a little bit of a distinction between our other statute with respect to coverage. But these are the public agencies subject to the OPMA. So it does not apply to the courts. It does not apply to the legislature. It does not apply to agencies that are not defined as a public agency, such as an agency governed by a single individual. So, for example, the Secretary of the Department of Social and Health Services, one person. When that one person is having a management meeting with his or her staff, that's not subject to the OPMA because the decider is the secretary, and that's one individual. Okay, so this applies to multi-member organizations. And then by and large, it does not apply to private organizations. And I've mentioned homeowners associations. If you could just spread the word out there, I get calls all the time with people upset with their HOAs and they want to apply the OPMA and it just doesn't. There's other laws, but it's not questions I can answer. So just if you could get that word out. In addition, even for those multi-member bodies where the OPMA does apply, there are certain activities of those bodies to which it does not apply, and those are codified in RCW 42.30.140. So, for example, there's certain licensing and permitting for businesses, occupations, or professions in their disciplinary proceedings, quasi-judicial matters, matters between named parties, matters governed by the Washington Administrative Procedure Act, which provides procedures for rulemaking and adjudicative proceedings of state agencies, not local agencies. And then certain collective bargaining discussions. It doesn't mean there aren't laws that apply to those things. They're just not this law. This is outside, those activities are outside the OPMA. So the meetings of the governing body by statute shall be open to the public and all persons permitted to attend except as otherwise provided. And then the statute goes on to define what is a governing body. It's the multi-member, again, board or other policy or rulemaking body, and this or was added later after 1971 by the legislature. Any committee of such public agency, when the committee acts on behalf of the governing body, conducts hearings, or takes testimony or public comment. So, for example, there are certain committees that are not subject to the OPMA. And we tend to, as shorthand, call them advisory committees. No offense to advisory committees, they do good work, but if they're not the decider or they've not been delegated authority, they're just simply maybe doing some research and shepherding it on up to the governing body, then those advisory committees are not subject to the OPMA. Now, having said that, there are a number of jurisdictions out there that even though their advisory committees are not subject to the OPMA, by policy or bylaw or ordinance, they have said to those advisory groups, you're going to be open anyway. And they do it by policy, but not because this law requires it. So what's a meeting? So as I mentioned, meetings of governing bodies are subject to the OPMA. Well, and I know this violates all kinds of statutory precepts. When you use the word you're defining in the definition, but I'm going to do it anyway, and then we'll just plow ahead. Meeting means a meeting at which the public agency takes action. And action means the transaction of the official business of the public agency and includes but is not limited to public testimony, deliberations, discussions, considerations, reviews, evaluations, as well as final actions. So it's a very broad definition. Those requirements are triggered whether or not final action is taken, and we'll talk a little bit more about that in a minute. But again, that sort of goes back to that precept where I was saying that sometimes boards think, well, we didn't take action, and by that they mean a vote. That's not the way this law works. Okay, just sort of set that aside. In addition, a meeting of a governing body occurs when a majority of its members, we often call it a quorum, although oddly the word quorum isn't used in the statute, a majority of the members gathers with the collective intent of transacting the governing body's business. So if you don't have a quorum participating with the intent to conduct the agency's business, and by that I'm setting aside now committees, so if you've established a committee, they are separately subject, but if you don't have a quorum, the OPMA's requirements do not apply. But there have been a couple interesting wrinkles, as I'm sure you can imagine, as technology has developed. So physical presence is not required. In fact, you have a member on the phone here today. But a meeting can occur by phone or by email. So, for example, an exchange of emails can constitute a meeting subject to the OPMA when the quorum is participating and discussing agency business. Now, contrast that with simply passively receiving information. So if you're passively receiving information, you get your board packet by email or you get an article that you need to read before the meeting. Passively receiving information does not trigger the OPMA. But where it gets tricky is, especially with email, and with that I will add text, and I'm going to talk about social media in a minute. When you send an email, a board member sends an email to another board member, are you 100% sure when you send that it is not forwarded on to other members and all of a sudden you got a chain of emails going, right? Or are you 100% sure that the member doesn't hit reply all or add the whole list of the board members and all of a sudden you've got a lot of communications going on? And what happens in these situations, and happened in a state Supreme Court case, then the state Supreme Court is going to start counting how many people were participating on that email chain. And maybe someone down at the lower part of the chain never did anything, just passively got some information and was done with it. But it's moving on, right? And so another area that this triggers in this same concept is what's called serial meetings. And where you are developing a consensus outside of the meeting in a way that's intended to avoid the OPMA. And there's some litigation pending on that as well in Seattle, for example. So some boards do are a variety of things to try to manage this, and they're kind of on a spectrum. And I'll just give you these as a teaching moment, and maybe you can noodle what might work for you. Again, there's that word "you," okay? So just be careful. So some boards that have a very low risk tolerance, they just don't have a lot of money to pay lawyers to deal with these things, prohibit board members from emailing each other. So that solves three problems. It solves a potential Open Public Meetings Act problem. You're never having to count emails and do all of that. It solves a Public Records Act problem for those boards. They don't have to be out there worrying that there's emails floating around that might be subject to a public records request, and where are they and what email account. And it solves a records retention problem because there are retention requirements for various kinds of communications, and you're not out there sort of wondering, gosh, is that one of the ones we have to keep for 6 years, or is that one we can dispose of immediately and is transitory? So that's what some boards do. Other boards do something else. So some boards require, for example, in the subject line of your email, that you say something like, do not reply, or do not reply all. Just sort of a warning, a gentle reminder that if you are getting one of these emails, please don't reply. And by the way, there's never a good reason to hit reply all. Ever. Right? We don't all need to know what you think. So that's what some boards do, is they put some rules of the road in place if there are going to be email communications, making sure that everybody's aware of that. Some boards require their board members that if they are sending emails, that all of them have to be CC'd to an administrator. Okay, so you've got somebody keeping an eye on it. Plus, you're also then retaining those records on an agency server. So if you have records retention requirements or public records requirements, you can find those. And other boards just sort of cross their fingers and hope for the best, right? So it kind of depends on your risk tolerance. It depends on your culture of communication style. It depends on what other issues you might have going. But a word to the wise that this is something you might want to think about. The newer issue that has been popping up is social media. So, for example, if one of you has a social media page, a Facebook page, and you're posting some interesting things about the Bar Board of Governors, and others of you are friends, and now you're all friending each other, and you're liking, and you're hitting like on some article, and it's all about agency business, you may be triggering a meeting because now you are participating in a discussion of agency business. And if it is a meeting that's happening on social media, what kind of meeting is it? Well, it's an illegal meeting, right? Because there's notice requirements, there's public participation or observation requirements, that kind of thing. So the new wrinkle to this old case called Wood versus Battleground School District and Citizens Alliance for Property Rights Legal Fund was also an email case. Now social media is also sort of presenting some of these issues. So another thing to keep in mind, as I like to tell people, I don't really need to be your friend. So, maybe friending is not the way to go on that. The other thing to keep in mind is it does not need to be titled a meeting. So it applies to retreats or study sessions or workshops. The title is irrelevant for OPMA purposes. It's the content of what's happening that triggers the OPMA requirements. And as I mentioned, but there's no meeting if there's no quorum. Oops, whoa, okay. All right. Something happened here. We'll just keep going. Let's see. It just took off on its own.
No names are available.
Okay. Yeah, that was funny. Okay. A little bit of no, it's okay. It just had a mind of its own for a minute there. Okay. So I've mentioned final action, and final action is a vote, obviously a vote on something, but it's also a collective positive or negative decision, a consensus. So sometimes you'll see a board say, hey, are we all in agreement that we should proceed with this contract, and there's some head nods or nobody objects. So you've got a consensus. And so when you have that final action, that has to be taken in public, even if some of the deliberations, and we'll talk about that in a minute, could be in a closed section. And secret ballots are not allowed under the statute. You need to vote in public. Now, the Act does recognize there are times when you gather for purposes other than conducting agency business. Maybe you are traveling, or you're carpooling, or you're at a Mariners game, or you're at a Seahawks game, or you're at a staff member's wedding, or something like that. And that's fine. The Act recognizes that. You just can't talk about agency business if you have a quorum that is in the car, for example. So just a cautionary tale on that. You can talk about the Seahawks or the Mariners or whatever, but you can't talk about agency business because that would trigger the OPMA requirements. So there's a couple different types of meetings. Regular meetings are those that on a recurring schedule that you've adopted by whatever process you use. It might be bylaw, it might be rule, it might be an ordinance. And those are the ones that are often, the first Thursday of every month, the second Tuesday of every month. They're on some recurring schedule pertinent to your agency. In addition, state agencies have to file a schedule of those regular meetings with the code revisor, including the time and the place. And those are then published in the state register. Those have to be done, I think it's by the end of January each year. And then if there are any changes to that regular meeting schedule, those also have to be published in the state register at least 20 days prior to the rescheduled date. So a couple years ago, the legislature added some requirements for regular meetings now, so we'll keep our eye on the regular meetings, and requires governing bodies to put the agenda online no later than 24 hours in advance of this published start time. There's a couple of exceptions to that, so agencies that don't have websites, obviously, and there's some mosquito districts out there and some other special purpose districts that don't have websites. It doesn't apply to agencies that employ fewer than 10 full-time FTE. For regular meetings, it does not restrict you from modifying the agenda. So if something comes up at a meeting like, oh, we need to approve this contract today, we're on a time limit, you can add that to the agenda at a regular meeting and take final action on it. Okay, you can go ahead and vote and all that. This requirement doesn't invalidate otherwise legal action taken where the agenda was not posted 24 hours in advance. So if there's some other requirements that you properly followed, you're okay. It does not satisfy public notice requirements in other laws. So if you have some other law, and there are some jurisdictions that have requirements that you post certain information 36 hours in advance or 48 hours in advance, you can't say, oh, well, we complied with the OPMA, we're good. No, it doesn't trump those other longer time requirements. And it does not provide a basis to award attorney's fees or seek a court order if a regular meeting agenda is not posted in accordance with this law. Now, in contrast, special meetings, and there's nothing special about a special meeting. They're just not a regular meeting. Can you tell lawyers probably drafted this law? So those are something that is not on your regular meeting schedule. Maybe there's a different day or maybe there's a different time, what have you. There is also a 24-hour notice requirement, again, somewhat like the regular meeting requirements. You have to post those. But in addition, you have to give that notice to each member of the governing body, unless waived, so you can't have any sort of surprise special meetings where some members of the governing body didn't know that there was a special meeting. You need to give it to each local newspaper of general circulation, radio and TV station, which has a notice request on file. So this is a bit of an artifact from the pre-internet era. So a local newspaper would tell a board, hey, I want all notice of special meetings. Okay, we'll put it in the file. Even though it's an artifact, it's still on the books. So if you have received those meeting notices, you need to make sure those members of the media get the notice. As a practical matter, pretty much everybody goes on agency websites now, kind of to see what the meetings are. Also do need to post it on your agency website with some of those same exceptions for small agencies. And then prominently display it at the main entrance of the agency's principal location and the meeting site if it's not the same location. And what this is designed to do is give members of the public breadcrumbs to follow you. So for example, if you usually meet at your agency headquarters, but you've decided to move it to a fire hall because you know you're getting a lot of public attending, you need to post the notice at your usual place and at the fire hall. Okay, so they can see if someone shows up and says, hey, I heard there was a city council meeting, but nobody's here. they'll see, oh, I have to go over to the fire hall. Okay, so it's to enable the public to better know where your meeting is at. Now, special meetings, you do have to have an agenda. The notice has to include the time, place, and the business to be transacted. And unlike regular meetings, you cannot take final action on any other matter that's not listed on the agenda. So let's use that contract example again. You say, oh, we forgot to put on the agenda the approval of this contract. The board needs to approve it. You can't do that for a special meeting. So what I usually recommend is that if you think there's any possibility that you might need to take action on something, and staff often sort of identify those things, put it on the agenda. Because if it turns out you're not ready to vote, or you need to kick that over to a future meeting, that's fine. But at least you've preserved your ability to take final action if you think there's a possibility that might be necessary. So there is a thing in the OPMA about emergency special meetings, but it's not what you think it is. And I always tell boards, don't get too excited about this. So the notice that we've talked about is not required when a special meeting is called to deal with an emergency. But the emergency has to involve injury or damage to persons or property, or the likelihood of such injury or damage, where the time requirements of notice are impractical and increase the likelihood of such injury or damage. So we're talking fires, floods, pestilence, also landslides, biblical kind of things. We're not talking, whoops, we forgot to do something, or something is really a high profile on our list of things to do. The OPMA does not deal with that use of the word emergency. It's only injury or damage to persons or property, the likelihood of such injury or damage. The one court case that's out there on this particular statute found that a teacher's strike was not an emergency. Okay, so you can see the high bar that has been set for emergency meetings. So the OPMA provides that an agency can't place conditions on the public to attend. You can't require them to sign in, you can't require them to show an ID, anything like that. They can just walk in, sit down, observe, and leave whenever they want to. But the agency can put in reasonable rules of conduct, and the OPMA does not provide any authority for a member of the public to address a board. Okay, there's no public comment period required by the OPMA. Now, some boards have public comment periods mandated in some other statutes, like the research universities, but it's not the OPMA. Having said that, a lot of boards have a public comment period. It's often at the beginning of the agenda, and they will set some rules of conduct. 3 minutes per person, please come up to the microphone, please introduce yourself. If there's a group of people, can you please designate one person to speak on your behalf? You see some rules like that, and so long as they're reasonable, they're going to be fine. But it's not an OPMA issue, because the OPMA does not require any public comment. In an older Attorney General opinion, and this I say older now because technology moves so fast, in 1998, we also said that cameras and tape recorders are permitted unless that would be disruptive. Back when we wrote that, we were talking about people setting up tripods and putting cameras right in your face. Today, everybody's got a camera in their cell phone, right, and their smartphone. So it'd be hard to envision most of the time how someone recording your meeting would be disruptive. So the Act does provide a process if you have a disruption, you have a group that's protesting or speaking loudly and it's interfering with the orderly conduct of the meeting. The OPMA does provide a procedure for dealing with that. And the meeting room can be cleared, meaning you can remove the disruptive people, or you can remove yourself to another room, to maybe a nearby conference room, that kind of thing. You do need to keep non-disruptive members of the media are permitted to follow you, because they're the eyes and the ears of the public for that. And you can only take final disposition on a matter that is on the agenda. So if you are moving yourself or removing some parts of the public, you need to stick to your agenda. There's a couple other details set out in the OPMA. Usually what I tell boards about this process is if you think that's going to happen at one of your meetings, you know you're going to have a lot of disruption, you want your lawyer right at your elbow because you're going to want to have that statute right in front of you and make sure you're carefully following the procedures. So we mentioned that all of the actions and final actions have to be taken in public unless a law permits you to close part of a meeting. And in this state, we call those executive sessions. They are codified in RCW 42.30.110. It's a part of a meeting that is closed to the public, if you will, for a specific purpose. And it is listed, the specific purposes are listed in the OPMA at 42.30.110. If it's not on that list, you are not going into an executive session. It's just the way it works. There are a couple agencies that have some other executive session provisions in some other statutes. Public hospital districts is one of them. But by and large, the vast majority of agencies that are subject to this law, if it's not in 42.30.110, you are not going into a meeting closed to the public. Unless it is the 140 list I told you, the quasi-judicial, which again is outside of this act. So if you are going into an executive session for one of the listed reasons in 42.30.110, there's a couple things you have to do. You need to announce the purpose of the executive session, and you need to announce the time that it will end. So here's a common announcement. We are now going into executive session to meet with legal counsel to discuss pending and potential litigation. We will be back in 30 minutes. Okay? Some boards then clear the public out and they just stay and talk. Some boards let the public stay and they move. It kind of depends on what your logistics are. Now, if you made the announcement and you're going to executive session and it turns out your lawyer is really long-winded and you estimated 30 minutes and it's wrong, you're going to need more time. The presiding officer then must extend that time by another public announcement, even if there is no one in the room. Okay? And I have done that on behalf of presiding officers before. I come out and I say, we're going to need another 15 minutes to a completely empty room, right? Nevertheless, you do it. Because at least for a lot of the agencies I work with, that is something that the state auditor looks for. They're going to be looking in your minutes for did you follow the right procedures. So it's something to keep in mind and make sure you don't miss that. Now, on the flip side, let's say you get into executive session and you thought it was going to be 30 minutes and it turns out you're completely wrong. Your lawyer says, it's hopeless, I have nothing more to say, and you're done, right? You cannot go back into public session early. You have to wait for that time period that you announced. And here's why. The members of the public that heard the 30-minute announcements might go off and check their voicemail or check their text or use the restroom or walk down the street. If you come back into public session early, they will have missed the opportunity to observe your business. And of course, that's the whole point of the law. So if for some reason you estimated wrong, incorrectly, you go stretch your own legs, check your own text messages.
I just had a question, and this goes back to extending the time. So you've extended the time to an empty room, and you've gone back in, and 5 minutes later, people show up because what they knew was you were going to be done in 30 minutes. Is there something you at least leave so that when those people show up, they know what's happening? Because you've probably gone someplace else. Right. They've come back, or you're in the room, but the door is still closed.
Yeah. Often what I will see in that situation is they'll leave a staff member in the room. And so when people start wandering back in, they'll say, oh, there was another announcement. You've got another 15 minutes to check your voicemail or do what have you. So that's usually what it'll do. The other thing to keep in mind is when you're building your agendas, there's a variety of ways that agencies do their agendas in terms of executive sessions. The best way, in my mind, is to either quote the statute, the reason that you're going into executive session, or provide the citation. And similarly, in your minutes, you're going to want it to be clear why were you in executive session. So we were in for discussing pending or potential litigation. So your minutes are clear about why you went into executive session. So I mentioned 423110 has a laundry list of reasons that qualify you to go into executive session. The legislature actually just amended this list this session to add one more relevant to public hospitals. So that will be effective, I believe, July 28th. So this will be tweaked slightly, but won't affect you. And you'll see there are some specific reasons, certain real estate, site selection or acquisition conversations, although that has recently been limited by the state Supreme Court in terms of the level of conversation you can have in executive session. Reviewing negotiations on the performance of publicly bid contracts where public knowledge would likely increase costs. We're not talking about the bid process. We're talking about reviewing the performance. So it's actually much narrower, and just a historical footnote that was written back to deal with whoops when a lot of contracts were sort of going under and they were trying to determine which power plants to shut down. Evaluating the qualifications of an applicant for public employment. You can evaluate the qualifications. You cannot make a decision in executive session. Meeting with legal counsel. We're going to talk about that one in a moment. That's a fairly common one. And then the other purposes listed in 110. So one that's shared by a lot of agencies is meeting with legal counsel. And it's not permitted just because legal counsel is present, although legal counsel must be present for this executive session. There's only 2 of them where that's true. This is one. Present can mean on the phone.
No names are available.
A lot of small boards that don't like to pay their lawyers to sit there for the whole meeting will only have them participate in the executive session if they're talking about this, and they may put them on the phone. You'll see that with a lot of small school districts, for example. So, but you can't go into executive session just because your lawyer is present. This was called the potted plant problem, and with the legislature, why they added this language. And what they heard, and I'm not suggesting it's true, I'm just saying this was, sometimes law by anecdote, is that some agencies were bringing their lawyers into the executive session, putting them in a corner like a potted plant, and then talking about whatever they wanted to talk about. It's like, no, that's not the way it works. So if you're in an executive session to discuss agency enforcement actions, litigation, or potential litigation, you do have to have your lawyer present. It's to discuss agency enforcement actions, litigation, or potential litigation to which the agency, governing body, or a member acting in an official capacity is or is likely to become a party. So, for example, you cannot go into executive session to talk about some cool case you heard about in Florida. Or you can't go into executive session to talk about your divorce. It has to be agency business, and that seems obvious, but nevertheless, it's in the statute. And then you make a decision that public knowledge regarding the discussion is likely to result in an adverse legal or financial consequence to the agency, which is why you are going into a closed session. So, for example, you will often see boards that are subject to this law, and I have been on the receiving end of this, turn to their lawyer in an open public meeting and say, well, Nancy, do you think we're going to get sued? Oh, my. And that's because the chair has decided a certain level of conversation is fine for a public session. Maybe some of the facts are already public, or, maybe it's his or her comfort level, or maybe they trust me to know where a line is crossed in terms of potentially privileged communication. So you'll often see boards talk about, some level of litigation, or maybe, and of course they would have to do a settlement in public, and not have that entire thing in the executive session. So there are penalties for violating the OPMA. A court can impose a $500 civil penalty as personal liability against each member who knowingly attends a meeting in violation of the OPMA. And there's a subsequent $1,000 a later $1,000 violation for a subsequent knowing violation. Now, even if the court finds that no penalties are appropriate because there was no knowing attendance, for example, at a meeting subject to the OPMA, a court will award costs and attorney's fees to a successful plaintiff in the OPMA. In addition, the court can declare the action taken, whatever the action is that was not in compliance with the OPMA, null and void. So if you use that contract example that I was using earlier, if at a special meeting a board approved a contract but it wasn't on the agenda, the court can nullify that contract. The other consequence, I don't have it on here, but for elected officials, so for school districts, water districts, that kind of thing, city councils, county councils, what we're seeing increasingly, I'm not saying it's a trend, but I am seeing increasingly allegations of violations of the OPMA in recall petitions. So, for example, when someone wants to recall an elected official for malfeasance or misfeasance in office, sometimes they will assert an OPMA violation. Often those don't make it through the recall process. There's a vetting process that happens. You have to go through the courts and determination whether it's a sufficient basis for recall. Nevertheless, we do see some of those at least the beginning stages that there's allegations of this violation, a violation of this law. There is a minutes requirement. It used to be codified in 4232. That was a remnant of that recodification that I mentioned from 1971. I think it was last year, maybe the year before, the legislature moved it into 4230 and sort of tidied up that last recodification cleanup. And it really doesn't say a lot. It says that minutes of public meetings must be promptly recorded and open to public inspection. You do not need to keep minutes of executive session of the content of the discussion. You have to say why you went in, and I suggest, when you come out, that kind of thing, but not the, he said, she said kind of thing. The biggest question I get about the minutes statute is there's no format specified in law. So if you pull up minutes from various boards subject to this law, you're going to see a whole garden variety of how minutes are maintained. Everything from what we call business minutes, motion, second, pass, vote, very clinical, if you will, to minutes that read like a transcript. He said, she said, he said, she said. Most boards have something in between. So they reflect the official business of the agency, the decisions made, but they'll also give some context, were there members of the public who spoke, or was there an extended discussion, or that kind of thing. So you'll often see, in my mind, the better ones are the ones that are a little bit in between. The other thing I tell boards about minutes is minutes are archival for state agencies. So, historians love minutes. I mean, they're like gold. So you really want to make your minutes as accurate and reflective of your agency business as possible because they outlive you. The other thing is it's a great gift to new members coming onto a board to read maybe the last year's minutes or the last 2 years' minutes so they can get up to speed and really hit the ground running when they start on the board. So it's a terrific transition element for them if you've done a good job in having your minutes accurately reflect your business, because they can then be more efficient when they start their official duties. So risk management, we do not see the level of litigation in this area of the law like we do the Public Records Act, which is a very, very volatile area. Having said that, as you're aware, there are some cases. So to try to reduce risk for the agencies that are subject to this, establishing a culture of compliance. So making sure that, the staff as well as the board understand what the parameters are and honor them accordingly. Getting training. Training is now required under the Open Public Meetings Act, for boards subject to the Open Public Meetings Act. That was agency request legislation by my office, which is why I'm out there training a lot, making it happen. But training does help do a good grounding and avoid pitfalls later, so training is a key element. Reviewing available resources, and we're going to talk about those in just a moment, and then taking the best practices from those. Keeping up updated on current developments in the law. I mentioned the legislature just tweaked the executive session statute brief a little bit this session, and to help you with that, we have an open government training page on our website where I've posted the training videos, PowerPoints, articles. One thing I do after the end of each session is I post a list of all bills that I'm aware of that passed that impact public records, and I post another list of all bills I'm aware of that passed that affect the Open Public Meetings Act, and I link those bills for you. So you don't have to do all that work yourself. I do it for you. I do not bill for that. You're welcome. But staying on top of that, just making sure you're implementing the current law. And then, as I said, other laws can govern certain other agencies' procedures, and there are a number of agencies that have other requirements outside the OPMA to conduct certain meeting procedures. And, of course, consulting with your legal counsel if you have questions. So I mentioned the Open Government Training Act. OPMA training is required for every member of a governing body within 90 days of taking their oath or assuming their duties. And refresher training has to occur every 4 years, no later than every 4 years. We have put free training videos on our website. A lot of organizations do their own training internally. They might have staff do the training, or they might invite a speaker like me. When we were working on the bill, we wanted to make sure it was very flexible. Agencies have a lot of different resources in bringing in trainers, and so we want to make sure that there was some accommodation for that, as well as providing free training online from my office. You can also contact us, like we're doing here today, and to the extent I'm aware of, like as I said, new laws, which I post, but other materials, I'm happy to share those. There's also formal Attorney General opinions out there for qualified requesters, and one of the things that we have posted on our website, for example, is a manual. It's an Open Government Sunshine Manual. No good deed. I last updated it in October 2016, and promptly thereafter the legislature amended a whole bunch of Public Records Act statutes, so I'm working on it. But with respect to the OPMA, not a lot has changed, so it still would be a good resource. And what I've done in there is provide descriptors of the law, and I've linked all the court cases for you. I've linked Attorney General opinions. I've linked any rules I'm aware of. So it's sort of a one-stop shopping resource. Again, I did not bill for that. You're welcome. So, I've also been posting some other guidance documents as I think they might be helpful. One, I kind of got tired of answering questions over and over from boards who were looking to fill vacant positions. So it's an executive director or administrator or a school superintendent. As well as some boards that are authorized to fill vacancies on their board. So if a school board director resigns suddenly, there's a process to fill that. And how you manage that with the OPMA. So what this guidance document does, it walks you through an FAQ where I answer all the questions that I received. To the best I can, and then I give some suggested practice tips. It's not a formal Attorney General opinion. It doesn't bind you. It doesn't bind anybody else. It's just me giving you what I think are some things to think about and some answers that I think would be helpful to know as you're joining into a search process. And for example, one of the common questions is, what about a search firm? How do they interact with us in the OPMA? And I've answered some of those questions in this guidance document. The Municipal Research Services and Services Center just has done some marvelous materials. If you're a checklist kind of person, I'm a checklist kind of person. They've got some practice tips and things to remember before, posting agendas and that kind of thing. I've shared copies of these with your staff. So they're just really particularly useful for anybody, but I just point them out there as another really good resource. Okay, so that's sort of the formal part of the presentation. Answered a couple questions, but happy to give it my best shot if you have some others, and if you don't, that's cool too. So.
Let's do just a
short, I know we got a recess, an official recess at 10, but a short, probably 3-minute break, Nancy.
I wouldn't mind that myself, thank you.
And then they'll start questions, so we'll be back in just 3 minutes, 3-4 minutes. We'll come back to order. I said 3-4 minutes for a short little break. And having that training just now, I put that actually on my stopwatch to make sure we're at 4 minutes. So we did exactly what we said we were going to do. We're back again. It's a question time for governors to ask questions of Nancy with regard to the training you just received. You've got Dan to my left. Anybody? Dan, go ahead.
Hi.
Hi.
Thanks for coming.
Sure.
I understood your advice as it relates to our meetings well enough. That was clear. My question, though, is...
Well, I wasn't really commenting on your me. I'm using the you.
Okay, fair enough.
The royal you. So.
My question is this. We have all manner of little groups and subgroups who do things for us at our delegation. You know, we have a committee that talks about what the content of the magazine is going to be.
Sure.
You know, from little things like that to a personnel committee. I thought I saw on there, but it went by so fast, that committees that report back to the body are not subject to the OPMA. Maybe I read it incorrectly. Could you provide some more explanation on those types of meetings?
Sure. So that was that advisory committees. That's what we tend to call them. So if advisory committees have no authority, they're just really sort of, if you will, almost a research arm. They're not acting on behalf of the governing body. They are not subject to the OPMA. But what I was also mentioning, because they don't govern. Just look at the verb, they don't govern. But having said that, there are a lot of boards that really, especially if they have lots of committees and different types of committees and pointed in various ways, that as a policy matter, as a policy call, through bylaws or ordinances, what have you, have said, you know what, we just want all of these meetings to be open, even if the OPMA doesn't require it.
All of our meetings are open traditionally anyway. I mean, that's always been our intention. So this isn't like some earth-shattering issue for us. I don't feel anyway. But is there a litmus test you can give us? I mean, like, for example, most of our committees don't have any authority. They decide things, they make recommendations and pass them up, and they have to be approved by the board. What I'm hearing you say is that type of committee, although it's always open to the public anyway, and we wish more people would come, it's not necessarily subject to the OPMA.
Right, and the San Juan County case kind of walks through this. So
No names are available.
It's a case you might want to take a look at, but that was a case where the committee, and I believe there was also some staff members on it, didn't have any authority from the governing body, from the county council, and so it was not subject to the OPMA. What some boards do with those committees that are purely advisory, so not subject to the OPMA, but they want them to be open anyway. This is my word, not a word from the courts or anything. They sort of do an OPMA light. So they'll say, we want your meetings to be open. We do want you to take minutes. But they might not necessarily get into all of the granular requirements that we went through today. But some boards just say, for their committees, just say, you're all in. You know, we just want you to all follow the same rules. We want you to post your agendas on the website. All of that process. So some of it for those advisory committees is kind of a culture and judgment call by your particular agency.
Get it, Dan? We have a follow-up clarifying question from Tara, and then I've got also Paul and Carla.
I hope people don't mind me jumping in, but this is one of the issues that I think we're struggling with the most. So could I give an example? We have a number of entities that don't regularly report to the board, but as Dan said, typically they can't take any action without reporting to the board and the board taking the action. But they do research, they may communicate with stakeholders, and they may work on something for years before they ever bring it to the board for actual action. So is what I'm describing, does that sound like something that is not subject to the OPMA?
Well, it's potentially subject to the OPMA if they're taking public testimony or public comment on behalf of the board. So there's a case called Feature Realty that talks a little bit, I think it's Feature Realty, that talks a little bit about that. And for that reason, when you sort of get into these gray areas of, well, it's not just the members sitting talking among themselves, but they've invited the public to come in, and the public isn't going to come in again and say the same thing to the board. That's just going to say it once. So the committee is actually kind of taking testimony on behalf of the board. And when you get into that area, those typically agencies, err on the side of making those subject to the OPMA because, one, they don't want to be the next test case. Two, it's not a hill they want to die on. And three, what's the downside? I mean, if culturally you have invited the public to those meetings anyway, as you said, there isn't a significant cultural shift in that. It is useful sometimes, particularly for boards that have many or complicated kinds of committees, and you may be one of them, again, the you, right, is to sort of chart out what committees do we have, what is their originating authority, what did we tell them to do and when. Sometimes committees live for years and years and years. They were created perhaps in the 70s or 80s. You have to go back to their originating documents and say, what authority did we give them, if any? And maybe it's morphed over time, gently, as the committees takes on more things and the board sort of has a consensus that's okay, but you didn't go back and clean up the originating documents. So sometimes it's a useful check-in periodically, and sometimes you'll see this happen with new administrations, for example, with new city council comes in there and they want an education. Okay, what committees do we have and who is on them and were they appointed and what's their charge? And it's sort of a refresher. And it might mean that the documents themselves need to be refreshed. If you say, I didn't know we'd appointed that committee 30 years ago to do X. They look like they're doing Y now. Is that what we want? Mm-hmm. I mean, you make a policy decision about your relationship between those committees and the board. And maybe you'll decide, we want to retain these decisions to us. They do not have any authority. Or maybe you decide we are too busy. We can't meet often enough to accommodate what this committee is covering. We do need to delegate some authority to them, and then we want them to report back to us what their decisions were, and maybe even keep some residual ability to change those if we need to. So it's something that may be different based on the actual charge of the committee. Thank you.
All right, I've got Paul and then Carla.
Thank you, Ms. Cryer. That was very informative and educational, but I do want to go on record, at least from my own perspective, to point out that the Bar Association's position has been, for many years, codified, as I understand, in opinions of our general counsels, that the Bar Association is not subject to the OPMA, and that is currently a matter of litigation. I am personally confident we'll win on that issue based on case law that says we are, among other things, an association sui generis and not a public agency. That said, we do strive for transparency, and so you could say we are complying with the OPMA light, but in a non-mandatory way.
Which is why I had my introductory comments. So I appreciate you're in litigation over this. So.
Just to clarify, Paul, you're speaking for yourself. You're not speaking for the WISBA, and you're not speaking for this board, correct?
I'm very comfortable with what I said, Bill. I hope that helps.
No, I'm just making sure on the record you're speaking for yourself, not this board nor the WSBA.
I find that an unnecessary correction or clarification.
Okay. Carla.
Nancy, my question is regarding some ad hoc committees that we have. We, for example, and particularly on the various litigation matters that are pending, we as a board had set up committees which are just temporary to work with the attorney who's been assigned to the case. There's been concern that, and there are committees of 3 people per litigation. There was concern that the committees couldn't meet with the attorneys because we had, I can't remember the statutory term, is it de facto decision-making authority? But the committees, as we understood them, were meeting with the attorney to talk about the case, bounce things off of the attorney's making the decision, or if it's a decision that needs, like it's the final version of an answer, that's up to the attorney. And then if it was something that needed to be attended to by the board that the committee had no authority to make that decision, it came to the board, and then the attorney comes and meets with the board, and then the board makes its decision. Do you have some guidance for us on, while I do have my own concerns that we're not subject to the Open Public Meetings Act, again, we all realize that's pending before the Supreme Court at this point. But for the moment, since we've agreed to voluntarily be subject to it, can you help us with these committees? Because right now we've stalled out. We can't even do anything because several of our committee members are concerned that we'll be fined if we meet with the attorney. And mind you, we're not making any decisions. We're just talking with the attorney. She's explaining to us the status of the case. You know, she's telling us, I'm doing this, I'm doing that, I'm doing the other thing. And so that's the scenario.
So it goes back again to what charge you've given the committee, and if they don't, no offense to who's ever on that group, but if they don't have any authority to make any decisions for the board on that, there is an argument that they're just less than a quorum that is being a sounding board, if you will. The other thing is there is a case out of the Port of Tacoma where the attorney was running some things by some council members, and there was a lawsuit, an OPMA lawsuit, and the court ultimately determined they didn't have the authority to, I think it was a settlement, to make the decision. No offense to them again, they just didn't have the authority. And if they don't have the authority to make the decision, then they're not doing anything. They're not governing. They're not making policy. Remember, it was a governing or policy function. So there's arguments, one, that there's no authority, and two, they have not been delegated any authority. May not want to call them a committee, but you know, that's up to you. So there are situations where an attorney for a board may need to meet with, or it's often like a chair and a vice chair, for example, where they might want to bounce something off. You know, should we head into mediation? Should we look at it as an option that I should bring back to the board? You know, that kind of thing, just sort of a gut check thing that doesn't necessarily trigger the OPMA. It's not a meeting. Again, no offense to them. They don't have any authority to make that decision. Yes, we're going to go into mediation. They're just sort of a sounding board. So the argument would be there, and it's not uncommon that that's not subject to the OPMA. They have no authority.
Is that everything, Carla?
Yeah, that was. Thank you. You describe exactly the scenario that we have here, and I mean I guess we're sort of a delegation to meet with the attorney. I happen to be on all the committees, but it's not a. We're not making any decisions. Anything comes back to the board for the board to make talk to the attorney about and make a decision as a whole.
Where it gets really tricky, and you're not in this position, but for 3-member boards. Anytime 2 members even bump into each other in the hall and talk about anything they've related to agency business, they have a meeting. So.
Would you like to have one follow-up on that? So, but if we don't have actual authority or de facto authority, then that's not an issue, right?
It shouldn't be an issue.
Okay.
All right, and I'm writing everybody's hand down here, so I'm not ignoring people. I want to follow up, though. Nancy, I'm curious, what's the application of the OPMA to the creation of these entities, the creation of a subcommittee or a committee of smaller number of folks? Is that subject, where the decision's made, we're going to create a committee and tell it to go do something?
That has to be done at a meeting. So if the board is reaching consensus on, yes, we need someone to work with the attorneys on a more day-to-day basis than we can do as a board, the board is making that decision, that's an action, and as well as a final action.
So hypothetically, if you've created these entities to go around these smaller groups to do things, and that's an action, and and if you haven't done that in public session, how would one go about redo? Is there a redo or?
There is a mulligan process, as we're in golfing country.
Mulligan,
here.
that's a good term.
There's actually an article citing to a case that talks a little bit about that, MRSC article, and basically I'm shortening it here for you, but if something happens that was supposed to have been done in public and it wasn't done in public, there's a process for going back on the record, doing in public what you should have done in public, as well as allowing public comment on that thing that you should have done in public, even if public comment hadn't been permitted before. It may or may not solve at the end of the day an OPMA violation, but it may resolve some of the issues for the court in terms of, well, you know, was it knowing because they didn't think they were in OPMA land and all of a sudden they were in OPMA land. When they found that out, then they went back and tried to do what they could on the record that should have been done on the record. So I get you a link to that article that kind of walks you through some steps to think about if you like.
That would be great. Is there any way to create a subcommittee, if you will, or a subgroup of the larger policymaking body without doing it in public?
No, not if the board, if it's an entity of the board. Now, having said that, let me back up slightly, because there are situations, and let's use a city council and a mayor, for example, and this often comes up. So the city council's doing its thing, and the mayor decides, though a single individual, so the mayor was not, and this is a scenario where the mayor is not a part of the council, so the mayor is a separate office. And the mayor decides, on behalf of the city, you know, I need to have a little ad hoc work group to help me on X, Y, or Z. Not being created by a multi-member board that is subject to the OPMA. That ad hoc group is not subject to the OPMA.
Okay.
Okay. So if the mayor or the head of an organization decides, that's not on the board, decides it would be helpful to meet with some people to talk about what park trails we need to adjust. That's not subject to the OPMA because the mayor himself or herself is not subject to the OPMA. So sometimes agencies will take that approach. They may be litigation against the city, but the mayor is trying to process some of it because the council itself only meets periodically. So the mayor is working through maybe some day-to-day conversations and maybe even with the chair of the council. So the chair is one person. Some ability to give some input to the attorney for the city without having it formally delegated as a committee, that kind of thing. So there is some process that some jurisdictions use when the group is not established by the multi-member board, nevertheless has the interests of the agency in mind in working with the attorneys on the litigation.
Okay, thank you. I've got PJ, Kyle, Russell, Alec, and Tara. Thanks, Nancy. PJ, you're up.
Thank you. Bill, then, are you contemplating that we're going to have a public comment and a revote on those committees sometime today?
I'm not contemplating anything, PJ, right now other than just trying to gather the information. That's it. I'm not commenting on, making any comment on what this board has done or hasn't done.
When we formed those ad hoc committees for the litigation, did we do that in open session or in executive session?
I'd have to go back and look at the minutes. I don't recall. I do want to note that because this is a special meeting, we cannot add anything to the agenda. It's a special meeting in the sense that we don't have a regular meeting that's published in the state register, and so our understanding right now is that all of our meetings are special until we can effectuate that.
Nancy, is that correct?
If you are a board subject to the OPMA and you have not published a schedule in the register as required, all of your meetings are special meetings.
Even though we only found out that we may be subject to it 3 weeks ago.
Yeah, that's a conversation with your attorneys. I'm just doing the 30,000-foot level here. If you're an agency, state agency that is required to publish in the state register, and for whatever reason you didn't do it, and sometimes there are various reasons agencies don't do it. They can't get the calendaring done far enough a year in advance in order to publish in the state register. So all of their meetings are special meetings, and that's, I wouldn't say it's usual, but it's not unusual for some boards to have all special meetings.
And this is just a reminder for everybody, you're really just trying to ask questions, generally questions for guidance from Nancy, we're not trying to get specific application, and that's why, PJ, when I said to you, I'm not contemplating anything other than just trying to get as much information as we can.
One of the requirements when you're discussing litigation or potential claims is that your counsel be present. In the case where you have retained outside counsel, but you also have general counsel who is on staff, is the presence of general counsel but not the outside counsel sufficient to satisfy the requirement?
It says, if I can pull up the statute, I think it says attorney representing the agency, and I don't think it goes into inside versus outside counsel. Hang on here. Let me pull up the statute. It's 423110. 1. Everybody forgets that other one. 1I. To discuss with legal counsel representing the agency matters relating to agency enforcement action, or to discuss with legal counsel representing the agency litigation or potential litigation, blah, blah, blah. So it doesn't necessarily say inside counsel, outside counsel. It just needs to be an attorney representing the agency.
And our general counsel represents the agency.
I will assume so.
All right. Do I understand that while evaluation of a potential hire that is within the purview of the board can be done in executive session, although the decision can't be made, the evaluation of an existing employee who is subject to the purview of the board must be done in public session?
No, you can do that in executive session.
Just the decision has to be made in public session?
If there are any decisions that need to be made, you have to do those in public session, and you can't even do a straw vote in executive session.
Okay. But you could have a discussion about the performance of the individual who reports to you?
Correct.
Okay. If you are involved, if the agency is involved in a claim or in litigation, and the board, the decision-making authority, wishes to allocate settlement authority to a group, to an ad hoc committee that's going to be involved in, say, a mediation, does that have to be done in public session?
So when boards want to be involved in settlement discussions and mediations, it gets very tricky. Because any decision by a board has to be done in public. If you are delegating authority to a group, a multi-member subsection, again, it's that same principle. If you're delegating authority to them to settle a case, that would have to be done in public, and the settlement itself has to be done in public, meaning if you accept the settlement, that has to be done in public.
So if your agency is going to go to mediation and you're not taking the whole board to mediation, could the board in executive session say, small group, you are authorized to indicate at the mediation that you will take back a favorable recommendation to the board up to $X for final action by the board? Would that be proper within executive session?
If you are making a decision, you cannot do that in executive session. But what I have seen some boards do, and this gets a little complicated, but what some boards do are these. The first thing some boards do is they have a policy in place, and this may be an area where maybe you want to think about a policy, but they have a policy, again, just the you up here, not the you here, a policy in place that, for example, says the attorney or the HR person or the risk manager has authority to settle any case up to $500,000. I'm just picking a number here. And so you've established that in policy, you have the discussion in public, you adopt the policy. And so any claims, maybe it's a slip and fall, what have you, the risk manager or the attorney has the authority to settle without further action of the board, but often the boards will require, we want to report once a month of what claims were settled in the prior month, that kind of thing. So that's one way agencies handle it, is they are forward-looking. They say, for a certain level of litigation, we're delegating to a staff, and it's a staff function to handle. Beyond that, the really big cases, no, we want to be involved. For boards that don't have that nice, tidy policy all wrapped up in a bow and ready to go anytime they need it, which happens from time to time, You will sometimes see a discussion when a case comes up, surprisingly or whatever, that a board will have a discussion in a public session, something along the lines of, we are going to ask, I'll just pick the chair, the president, the chair to work with our attorneys to participate in a mediation so long as any settlement proposal has to come back to this board for discussion and for final approval in an open session. So that's how some boards handle it. You go into public session, you acknowledge you're in some sort of litigation process, you want somebody to work with the attorneys, but they don't, again, no offense to them, they don't have any authority to settle the case without the coming back to the board for a final, often discussion in executive session, and then if you're going to make any final decision, that's done in public session.
So you can't...
Hey, PJ, how many more you got? Because we got a list of people and we're going to run out of time. So I hate to be the hammer here, but just one more maybe. I know you got probably a fleet of them. It is important. I just want to make sure everybody gets the opportunity to ask questions, Carla. That's all.
So the board in an executive session prior to sending people to the mediation cannot indicate an economic area in which they would be open to final approval.
You can have conversations. You cannot have votes or straw votes or develop a consensus.
All right. Last question.
Sure.
Assume for a moment that one or more members of a board send out public newsletters reporting on activities of the agency, and they do this on their own, but that a majority of the members of the board are recipients of that newsletter. It's not something you reply to. Is that creating any kind of open meeting issue?
Not if it's passive receipt. Okay. So, yeah, it'd be like any other article. Let's say you come across an article that you think is really helpful for the board and you send it out. So long as it's passive receipt. Now, where it gets tricky is, and this is where some boards have gotten in trouble, is somebody gets the article and then goes to you and says, I received a copy of the article, I don't agree, and then you start the daisy chain of going around, of having further conversations. So you just need to be, everybody needs to be on board if you're subject to the OPMA that, when you get those things, if you want to discuss them with a quorum, you discuss it at an open meeting. So, hey, great article, great newsletter, I'd like to talk more about it among the board. That's done at a board meeting.
All right, being mindful that we have 20 minutes left in this discussion.
Those are
Kyle,
some pretty big clocks there,
yeah,
I have to say.
There you go. Kyle, you're up.
Thank you. I have just a brief question, and not to be too specific, but I'm trying to figure this out in my own mind too. If we had and I'm going to pick on one of our groups, our Civil Rules Committee or work group, we send them out to determine what kind of changes need to be made to the civil rules. And they come up with an idea that they want to have early mediations, just as an example. And this is actually kind of based on what we've had before. How do they go about determining that within the OPMA? Because I understand they're not actually taking any action. They're going to be making recommendations to the Board of Governors. But what regulations and guidelines do they have to adhere to when they're actually trying to figure out what would be in the best interest of the membership and the rules?
So if they don't have any delegated authority, the OPMA is silent on rules of the road internally after that point. So for that reason, a lot of agencies use Robert's Rules of Order. They may use Alice Sturgis, another parliamentary procedure guide. They might have adopted their own version of sort of Robert's Rules Light about, now that you've had this task assigned to you and you don't have any authority, frankly, to make the decision, what we'd like you to do is X. We want 4 meetings a year and we want you to report back to the board every 2 months or whatever it is. But those are all internal and policy setting and sometimes using things like other outside parliamentary procedure guides.
And so not subject to the OPMA and those
If they're not subject to the OPMA, then they're not subject to the OPMA, and after that it's a policy call on how they operate, unless there's some other law, and there are a few of those, planning commissions, that kind of thing, have some other laws. But
so if that group then wanted to disseminate to the entire committee
their proposal for these rules, that would be fine. It's still not subject to the OPMA.
If they're not subject to the OPMA, they're not subject to the OPMA.
Okay, and does it make any difference then if they then solicit public input?
So where the solicitation of public input gets a little tricky is, you might remember the committee definition included receiving public comment or testimony. And if you're doing that on behalf of the board, so you're not anticipating that these people will come forward again and replicate their testimony, or they haven't said, for example, go ahead and make a transcript of my testimony and give it to the board, there it gets a little grayer. And for that reason, a lot of agencies where they are sending groups out to solicit public testimony and comment will make them subject to the OPMA.
Got it. Thank you.
Not the hill they want to die on.
Thanks, Kyle. Russell?
I'm wondering if you can provide some best practice advice for these committees. So in the case where you have an advisory committee, not a quorum, no decision-making authority, does choosing to open those meetings up to the public pose any risk that we're also opening ourselves up to document requests about that advisory committee, and how do we guard against that kind of thing?
Well, as I mentioned to one of the governors earlier, to quote Justice Alito, democracy is not for the faint of heart. So, opening up meetings where the public might be interested is not a bad thing. Yes, there may be consequences. There might be records requests, that kind of thing. But that's all part and parcel to, a democratic process, if you will. The one hesitation I have, if you will, there was a bill pending that's been introduced a couple different times now in a couple different versions that would have required advisory committees to be subject to the OPMA. That bill did not proceed this session. As part of that conversation was, or a part of that conversation was, if we are now opening up advisory committees formally to the OPMA, we're saying, yes, you're subject. That also makes those citizens who are just wanting to be in an advisory committee to talk about a parks trail suddenly potentially personally liable because they have stepped up to volunteer their time to help government. So one of the reasons I mentioned sort of the OPMA light is for those groups that are not formally subject to the OPMA, but you want them nevertheless to have some public participation, if you will, or public observation opportunities. You might put in your bylaws, your ordinance, while not subject to the OPMA, we nevertheless would like this group to have their meetings open to the public, and please keep minutes. It might be, like I said, something light. But by formally saying, we've decided you are subject to the OPMA, all advisory groups, you may inadvertently open up an opportunity for someone who is unhappy with that advisory group to sue under the OPMA, even though technically they're not subject to it. So something to think about in terms of some possible consequences for volunteers.
Or anything else, Russell?
Just to follow up, so I think one of the terms you just used is saying, we're saying this advisory committee is subject to the OPMA. That's probably beyond our authority to say it is or isn't.
Well, what I'm saying is some jurisdictions have said, because of the charging documents and the authority that they've given certain groups, that they conclude they are subject to the OPMA. Like, they look back and they say, yep, I think we're in. Now, we don't have a court case, we haven't been sued, but we think we're in. So this group of advisory groups, you're in. This group of advisory groups that we've set up, we've gone back to the charging documents. No offense to you, you've been delegated nothing. You have no authority. You're not in, but we would really want, what we want as a policy matter is we want you to have these meetings open to the public, and we want you to take minutes or whatever the criteria are. So you'll sometimes see a breakdown of types of committees, advisory groups, advisory boards set out based on their charging document, and then either hey, you're in. Okay, so you're following this 100% because that's what we've concluded, and we don't want to take the risk that we're wrong. Versus some other groups that may be ad hoc, they may be existing for 6 months to just give some very general feedback on a very transient topic, and no need for them to exist forever. They're not, again, have no delegated authority. yeah, we want your meetings to be open, but you don't want to bring those folks in formally. We're making a decision, you're subject to the OPMA because of the potential liability for those volunteers.
Thank you.
Thanks, Russell. Alec?
So thank you very much. Actually, my question goes to the head of the table, and it really is, I guess, Tara and Julie. Perhaps not now, but I would certainly like, after this presentation, for example, you mentioned that all of our meetings are now special meetings. I missed that. Maybe other people saw that. But I would like, given this presentation, some walkthrough of where we are, I guess, complying with both or one or the other in terms of where we are with our committees. You had a question regarding committees. Those were not just advisory committees. There's a question about committees of the board, but I think we have practices that make those public meetings. So I'd just like to know where we are, and it's not for Nancy, but it's for you, and hopefully before we leave, and if not, then definitely in Richland. Thank you.
Thanks, Alec. I have Tara on the list.
Thank you. So one question is a follow-up to Kyle's about committees that maybe they don't have delegated authority, but maybe they gather public testimony. Would it be appropriate that the majority of their work is not subject to the OPMA, but maybe the meeting where they gather public testimony, that is treated under the requirements of the OPMA?
So this is a question MRSC and I have talked about. A lot of this area, by the way, it's not like the PRAs. You can cite to this case, this case, this case. It's a little bit different. But before he retired, one of the attorneys at MRSC and I had talked about this, and we agreed, yes, there are probably situations where a committee has some delegated authority for certain things, so those would be subject to the OPMA. And they don't have delegated authority for other things. They're just advisory capacity on those other topics. Maybe there's 3 things that they have delegated authority and 5 things that they do not have delegated authority, in which case only part of their meeting would be formally subject to the OPMA. Having said that, what happens, however, if only part of the meeting is subject to the OPMA and then you try to close the rest of the meeting, this conversation we're having here, you would have to have with the members of the public who want to know why they're being excluded. So I would suggest it's not a best practice. You've asked my feedback on best practices. I would suggest it's not a best practice. It may be legally permissible, but it may create more questions than answers and create some awkwardness. So something to think about.
Yes, Tara.
Sorry, one more question. And this may be a silly one, but it's one that I have not gotten an answer to yet. So the OPMA is triggered when a majority of the governing body engages in action liberally defined. If we've determined that a committee or a body is acting under delegated authority and is therefore subject to the OPMA also, does a majority of that smaller group also, does that become the measuring?
They are separately subject to the OPMA.
Okay, thank you.
Right. So if you have a committee of 3 to talk, that's a meeting.
And what? Did you have more questions? Anybody? I'm looking for hands here because I had a question. No. Okay. In that scenario, just kind of following up, you'd mentioned if there's a $500 civil penalty, and then it could end up being $1,000. I'm curious how those count. Like, is it for each violation? Does it accumulate up to, if there's 10, 20, I don't know. Is that how it works, or they just...
Well, we don't know.
Okay.
It's that change from 500 to, it was 100, by the way, for like 40 years.
Okay.
And then it was changed in our legislation to 500 and then 1,000 for a subsequent violation. It's actually, the violation is attendance. Attendance at a meeting. The violation isn't like per vote, it's attendance at a meeting. So there is not case law out there on that yet, on how to calculate that. Typically, what I've seen is when there are OPMA lawsuit settlements, it's often some sort of global settlement. It'll be $15,000 or whatever, and no breakdown of in the settlement, like, okay, here's how we did the math. Often you don't see the math in a settlement agreement.
Right.
So it will be some conversation back and forth between the sides, and, well, I think you had 10 violations. Well, really, we only had one because it was only one meeting. And, you kind of, I'm assuming that's the way the negotiations go, and they come up with some mutually acceptable dollar amount that will compensate for the attorney's fees and maybe some extra for penalties. I have also seen on occasion, and I just had a conversation with another attorney about this, sometimes a board, as part of imposing a penalty on itself during settlement negotiations, will donate $500 per person from each individual to a fill the backpacks fund for school or something like that. They'll say, our settlement agreement doesn't separately call out how many violations and all of that, but what we're willing to do is we're willing to pay you, plaintiff, X amount, plus we are willing individually, sort of as a self-penalty, to donate $500 per person to the Better Parks Fund or something like that as part of a creative settlement process.
And is there one last question for Nancy? Is there a case that you could point us to where the court had to drill down on a particular body and say we think and determine you're an agent, you're subject to the act? Like, is there a set of tests they're looking for in an opinion that we could look at?
I'm assuming you probably briefed a lot of what I would know in terms of what is an agency.
I'm pretending I haven't.
The cases out there about what is an agency. We've got some cases with respect to associations and the Public Records Act, for example. We've got the Association of County Officials, if I remember right, on the OPMA issue. We've got the Superior Court Judges Association in a PRA lawsuit where the court determined that they were subject to the judicial branch rules of the road on accessing records. So there are some associational cases out there, whether they in or out as an agency, and I'm sure that's something you'll be further exploring with the court.
Okay. Good. Thank you, Board. Any other questions? If not, we're gonna close this training session down and say.
And just as a reminder, not an official position of the Attorney General's office.
Yeah.
This is just me talking.
And I want to. I got them too early here. I know that we don't have to have public comment on this, but we are gonna have a public member with Nancy. You have a question? All right.
Oh, a question. Sorry.
Yes. Sorry. I
was
stopping early.
I have two little questions.
Sure.
This whole idea that now all our meetings are special was a surprise to me as well. And so I vaguely remembered and then just looked up that it says if you have a special meeting, you have to publish it in the local paper if someone has made a notice request. So I wondered if anyone has made a notice request and if we're supposed to be publishing. So that's one issue to worry about. This afternoon, later this morning, we're going to be doing some votes, or they'll be doing some votes. And when I've seen those votes before, they're always like people write something down and then somebody counts them and the candidates are out in the hall and then they come back and make the announcement about the result of the election. And you said there can't be any secret ballots. Is that considered a secret ballot? Is there a different procedure that needs to be followed? Or is a secret ballot something else altogether?
So on the first issue, there actually is no publication requirement. What the requirement is for special meetings, if you have a notice request on file from those listed media, you have to give them notice of your meeting. What they do with it is up to them. If they publish it or they put it on their web page or they put it in their local hard copy newspaper or whatever, it's up to them. They're only entitled to receive notice. There's no requirement they actually do anything with it. So that's just sort of a process issue. And the voting, yes, the voting does have to be in public. And, yes, it can be awkward. And yes, you'll see boards all the time having to say how they voted on something, and it may be awkward, but it is what it is. It's part of the accountability process with the OPMA.
Thanks, Nancy. Jim, you got the last shot here.
Yeah, three quick comments. I'm personally not willing to state that the Bar Association is subject to the Open Public Meetings Act, and I think that you guys should listen to your lawyers. Secondly, I'll remind you, well, I guess, since I've been attending these meetings for 20 years now, I remember that the vote for president always was public. If you used to raise your hand, we all knew who voted for who. That changed. So just as a reminder on that. The last thing I'll say is that you've been talking about committees. I do want to remind you that you do set up a lot of task forces, but I will remind you that the task forces do not always get the approval of the board, including one that I did for many years and came in with recommendations and was totally shot down. So I can give you personal information about how that works, so that you're not always giving authority to these groups. So when you're saying committees, frequently it's task forces and it's other amalgamated groups of people. But we have made an effort, and I think everybody in the room will say this, to reach out to get input from those who have positive comments. Normally other attorneys, but if public people came, we wouldn't shut them down. Those three comments. Thanks, Bill.
And if I can just add,
yes.
the title also, the task force versus committee, is not relevant. So it's the business that's being conducted.
Okay. Super, Jim. Thanks, Nancy. Thank you very much.
Sure,
very,
thank you.
very
Appreciate
helpful.
it.
Appreciate it.
Well, good luck.
All right. We are.